for tuning in. My name is Brad Nicklin. I'm the attorney and managing member of the Nicklin Law Group, which is a law firm concentrated in empowering men and fathers in divorce, custody, and family law matters, with offices in Nutley, Montclair, Saddlebrook, New Jersey. I'm also the proud author of How to Survive and Thrive When Divorcing a Narcissist. You can find the book on Amazon.com in a Kindle version and a hardback copy by searching my name or the title. I hope it helps you or anybody facing these issues. Today's video is part of my ongoing series, #FamilyCourtSucks, in which I try to impart both legal and practical aspects for my viewers and clients about what they can and can't expect inside of these matters. But before we go forward, if you like this information or any of my other videos, please subscribe and give a like to this video so others get to see it. Today's video is #FamilyCourtSucks because judges have little accountability. Now for the caveat. Not saying that there's no accountability, nor am I saying that they act negatively or arbitrarily because of that. I am saying there are several reasons that I believe judges can make decisions more freely than they might otherwise. Now, of course, judges are bound by the laws of our state. They're bound by New Jersey state statutes, as well as their own ethical and personal integrity. Additionally, we have the appellate division, which is a court system that reviews their decision with the power to change or suggest changes. There's also an office called Administrative Office of the Courts, which handles the daily administration of the judges in the court system. And lastly, there's a person or an office titled the Ombudsman that provide a bridge between the courts and the community with the goal of enhancing public access and improving customer service. So while this is all helpful in the general administration of our justice system, I still feel judges make decisions because they know that the average litigant can't avail themselves of these resources. Whether or not you have an attorney, the laws of the state and the personal integrity of a judge mean little if there's nowhere to go with an adverse decision. I mean that most decisions during a divorce and family law matter can't be appealed until the case is over. There is a process for what's called an interlocutory appeal, on which I won't go into length, but I did include a link below for those interested. There's also a process to seek reconsideration of any adverse decision during your case. Still, you have to be able to convince the judge that he or she acted arbitrarily or capriciously, or at least without the actual facts or information. This is a very challenging standard if you have nothing new to offer the judge other than what this information you originally provided was, which led to the negative decision you received. So this leaves you two questions. First is, what are your options? Second is, how can knowing this help you? So the first option is always to avail yourself of the rights you have to seek an interlocutory appeal or a motion to reconsider if you feel the law and facts of the case support one. In some circumstances, you can seek the recusal or removal of your judge from your case if you believe that there's a bias or a conflict with the administration of your case or the decisions you're receiving. Again, I'll list some videos below if you're interested in more information about this topic. And lastly, you can always seek to remove your case from the process by opting for an alternate dispute resolution process. Again, I'll also list some videos that explain the different options available for you there. So then my second question posed is, how does knowing this information help you if you're not able to avail yourself of the options I just mentioned? Well, I always believe knowledge is power. It at least helps you to prepare for the problems, delays, and the costs that you may incur waiting to get the right decision. Also, I recommend that you use this knowledge from the onset and plan your case and strategy accordingly. You should always discuss with an attorney the range of likely outcomes, remedies available to you, and what your judge is likely to do. Now, no lawyer can give you certainty on these issues, but any experienced attorney can provide you some range and some predictability for the judge in your case. Lastly, use this information to brace yourself. Make sure that you're funded to address the significant issues. Make sure you understand the costs of such matters. And of course, the steps you'll have to follow to have a satisfactory conclusion. This may mean let it be known if you're preparing to go to trial. Make sure your adversary knows that you're keeping the record clear, possibly for a subsequent appeal. Order the transcripts of these hearings to prepare for when the time is right to seek a new decision or go to trial. These steps will prepare you to handle your issues, but they'll also alert the other party that you're moving in that direction, which could force them to a more amenable resolution so they can avoid their own costs and delay. Hope this information helps you. If it does, please give a like and share it so others get to see the video. You can also subscribe so you get notices when I go online, and you can post any comments, questions, or topics you would like me to cover. Thanks and stay safe. Here's my contact information if you have any questions or would like to schedule a meeting.